That's why I think we're here. Is that why you all think we're here?
It is, Judge. I guess my only question would be how you want to proceed with this. My client filed his motion for contempt and to modify the parenting plan first in time. In response to that, we got the CR 60 motion asking to set aside the contempt that we're here on. So I normally we take that CR 60 first, but again, I don't think it matters because everything's closely intertwined and related. So I'll leave that up to you as to how the court wishes to proceed.
Thanks. Ms. Green, any comment on that?
Your Honor, my same question is how you wish to proceed since there are several matters.
Yeah, I think my preference would be to go in the order that I announced and to hear the CR 60 motion and then the motion for contempt and then the motion to modify.
Okay.
So let's jump right in. I've read the briefing, so I have the copies of the documents here and I've taken notes on the same. So I'm happy to hear arguments from both parties.
Thank you, Your Honor. So regarding the CR 60 motion, my client filed that within the year required by the statute. My client filed it based on fraud, misrepresentation.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Now, let's break it down. Today's case revolves around a bitter custody battle, full of twists and high-stakes emotions. The parties involved are here to determine whether a mother's actions have crossed a line, and if so, what the consequences should be. The tension is palpable. Accusations of control, potential child alienation, and even allegations of misconduct against the father. Hold on, because we're going to unravel the truth together, one motion at a time. Let's see how this will unfold.
And other reasons justifying relief. My client felt that the CR 60 motion was necessary because the rulings made in this matter were excessive, unreasonable, and not based on the facts in the case. The first issue my client had was regarding the severity of the penalties. There was a threat of potential jail time if she violated again. There were costs asserted against her for the prevailing party for attorney's fees, but there was no consideration given to the financial ability of the parties or the financial need of the parties, which is required by the statute. Additionally, the court found that my client was violating the decision-making clause by unilaterally engaging the child in counseling. The counseling the child was engaged in was previously ordered by the court and had continued since the previous order of the court, which is actually made by Your Honor. So as far as her making unilateral decisions in counseling services, that did not take place. The child had continued counseling from a prior court order. The issues that father brought up were his lack of contact with them. Their not having contact with them was found not to be truthful because there's communication in the record that there hadn't been contact from father about counseling service whatsoever. So the basis that was made on was erroneous by the court based on the false evidence presented by Mr. Curtis about his involvement in the counseling. Regarding mother removing the child from school, that violation was provided ample evidence that the child was in counseling, therapy, and other treatments during the school time. Those medical appointments were all provided in the record to document the reason the child had missed school, and the tardies were related to the child's bag checks after the knife incident that was in the court's record as well. So nothing my client did took the child out of school excessively that would have applied for a violation under the statute or under the clause that she had violated the excessive amount of unknown reasons because father was aware of the bag checks, father was aware child was going to counseling. There was nothing that father was unaware of or that was excessive in the in the child's care that would have amounted to contempt on that issue. Regarding the derogatory comments, most of the incidents that were based on or that were found as derogatory comments violations weren't actually any.
Let's pause here and break this down. Miss Green, representing the mother, argues that the rulings in this case were excessive, particularly regarding penalties that could have potentially involved jail time. She points out that financial considerations weren't taken into account, something crucial in family law. The mother claims she wasn't in contempt, citing the child's ongoing therapy sessions as evidence. However, the father's allegations of her withholding contact and misrepresenting facts present a complex web of accusations. The courtroom needs to figure out where the truth lies. What's the core issue? The child's welfare and the parent's ability to co-parent effectively.
Comments whatsoever. Issues brought by father showed violations based on derogatory comments for stating that the pocket knife was somehow a derogatory comment against father. It's an act that mom did not actually provide the pocket knife and did not make any comments to the child derogatorily to father. His statements are all based on supposition. He wasn't there and doesn't know the circumstances surrounding the child getting the knife. So using that as a basis that was used to harm father against the child was not appropriate, as well as other facts of basically changing the child's name. There was nothing provided by father that showed that was either derogatory towards him or that it actually occurred. All these were all statements made by father, and based on the statute, there has to be ample facts, even if in light of the favor of the probable contemptor, that there has to be ample facts to show that the client was in contempt. My client was not in contempt. All these violations were not amply proven and were disputed clearly in the record. Finally, the other issues regarding the mental health evaluation that was required. The biggest issue is that there was nothing provided in the pleadings that requested that. It was not in the motion. It was only in declarations as reference only that the mental health evaluation needed to be completed. It is an example of overreach. There was nothing in the contempt that showed that there was a need for mental health treatment for my client. My client is in mental health treatment. And at this point, it is financially unfeasible for her to complete the mental health treatment. She's on furlough, and due to the government shutdown, there's no way for her to complete it. That'll go into the next motion, but I do want to state that for the record that there has been no finding that was substantial enough to show that mother needed to complete a mental health assessment and that she's in any way danger to the child. If the contempts are not found in light of the CR60 motion, then there should be no need for the mental health assessment, which is the next issue in the case.
Pretty good. Thank you, Ms. Green. Mr. Sandy?
Again, I think this one largely speaks for itself, Your Honor. This was a case that was heard by Judge Hahn, not this past summer, but again, we're going back to July of 2024. It's a case where the court had very significant concerns about the conduct of Ms. Nguyen. I think if you reviewed that contempt order from July of 24, you can clearly evidence that. I don't know how far you got in your review of this, but if you look at the declarations in that contempt, if you look at the exhibits in that contempt, I think it was all crystal clear as to what was going on. The court did impose again and signed off on that order back in July of 2024. At that time, there was no motion to reconsider. There was no request for a review hearing. There was no clarification that was requested from Ms. Nguyen or her counsel. We don't hear anything. And again, I think this is going to dovetail with kind of the control mechanism that you kind of get here at ad nauseum today about the issues with mom. We don't hear anything until after we file our latest contempt and after we file the motion to modify the existing parenting plan, that then they spring this CR60 motion. The CR60 motion, now we're hearing about furloughs, we're hearing about these types of things, which again aren't contained in the pleadings. I'd ask the court not to consider that. We never heard about that certainly in July of 2024. And again, if there's no request for review on a motion to reconsider, again, I think the court has to deny this. And again, I think from a legal perspective, if you look directly at CR 60, I think it's pretty clear. It states in part, the motion shall be made within a reasonable time period. And for reasons 1, 2, or 3, not more than 1 year after the judgment, order, or proceeding was entered or taken. What that tells me, and typically we see CR 60s on a final basis. What this tells me is that the rule is contemplating it's got to be number 1 within a reasonable time period. So if you look at the history of this, this is a contempt order. To sit on that and wait almost to the day, a full year before you file the CR 60, realizing that you as a party or you as an attorney, your client, is not complying with that order, again, is not reasonable time period. If a CR 60 was to be filed timely, that would have been within a month or 2 after a review, a hearing, after a motion to reconsider. And again, we have none of that. This is now trying to whitewash basically the history of this case and say, well, here we are once again in trouble for which, and again, I'll address this on my contempt argument, pretty egregious violations of a clear order, and to kind of skirt that, well, I'm going to try to now file this CR 60 under this 1 year time limit, which I would agree, you have up to 1 year to do that under normal circumstances. But the circumstances here are not reasonable, given this is just a contempt order. And we've got a young child who needs finalization on this. We got 2 parties who have been going at each other in litigation now for an extended period of time. While my client has been waiting, I have been waiting. And again, I'll get to this. The GAL has been waiting for over 1 year now for this mental health evaluation with a parental risk component, with input from everybody that we haven't gotten. So we're sitting here idly by, and then we get a CR 60. Clearly, this is retaliatory. I think that's obvious. Clearly, I think it's in an unreasonable time frame, given the clear language of the statute. And again, I think this is one where it fails both factually and legally from both precedents. If anything, this was Judge Hahn's order. I think it's crystal clear. It's very easy to interpret. We just have somebody who doesn't want to do it, and now she's looking for backdoor ways that she can try to circumvent the clear order of the court again and eliminate any responsibility on her behalf. So essentially, and I know that we are loath to find bad faith, frivolous pleadings and the like, but I would think this gets as close to that as it possibly can, given the circumstances and the timing of this. We are asking for $1,000 in fees. Again, I just don't think this is made in good faith. I think the evidence is pretty clear to that. And again, if you look at the timeline, it's exceptionally clear. So we are asking you to deny the request for CR 60. We are asking you to impose a sanction or attorney's fees, or both.
Thank you. Ms. Green, any rebuttal?
Yes, just briefly. I did forget to mention regarding the delays, those are not entirely the fault of my client. I have had several medical issues, which Mr. Zandy is aware of throughout this last year. It's documented in the contempt motion.
I'm going to object anything that's not before the court.
Right now, the father's attorney is making a bold move, accusing the mother of stonewalling and refusing to comply with the court's order. And this isn't just about a few missed phone calls. We're talking about months of delay, leaving a child in emotional limbo. This, folks, is where the drama reaches its peak. We hear about a child's need for a mental health evaluation, but there's been zero progress. The mother's attorney, however, brings up her financial struggles and health issues, making the case about a parent who's trying but has been blocked at every turn. So, whose side are you on? Is this negligence or genuine difficulty? Let us know your thoughts in the comments below. This case is boiling over.
And it's been almost 1.5 years. I'm not aware of anything related to Ms. Green's issues over the course of the past 1.5 years outside of what's occurred since we filed the motion in July. But I don't think that's right.
There is in the materials, the reason for the delay mentioned was intermittent illness. So I just wanted to bring that up of her attorney. So I do want to bring that up, that it's not entirely at my client's fault.
Yeah, I do recall reading that. Anything
So
else?
I'll stop there since that's what's in the pleadings.
Okay, great, thanks. All right, I failed to recognize Ms. Quarries here also as the guardian ad litem. Just wanted to recognize her. So this is a CR60 motion related to Judge Hahn's order that was entered on July 23rd of 2024, a contempt order. The basis of the CR60 motion is CR 60 parenthesis 4, fraud, misrepresentation, or misconduct of the opposing party. Here, Mr. Curtis it's alleged, and also subsection 11, which is for any other reason justifying relief. So the couple of different things. I think what stands out fairly clearly is the time frame. I've recognized that CR60 it makes specific mention of a 1-year time frame, and that's specifically for let's see, where's that? Oh, there it is. The motion shall be made within a reasonable time and for reasons 1, 2, and 3, which is mistakes, inadvertence, and then erroneous proceedings or newly discovered evidence, which is not one of the items that was particularly pled. So it has to be within a reasonable time and then not more than a year for the 1, 2, and 3, subsections 1, 2, and 3. So the timing is clearly, it catches your attention right out of the box. That there was a motion filed by Mr. Curtis related to contempt and a motion to modify, and then on the heels of that is a CR60 motion to change some of the different items that Judge Hahn had made findings on it. And Ms. Green, on behalf of her client, argues that the penalty was excessive, over the top. I think, when a judge says, hey, look, we're kind of pushing the envelope here, and then mentions incarceration as a potential penalty, that may come across as very harsh. I understand that, because freedom is to be cherished. And it underscores maybe the thoughts of the judicial officer at the time, saying, hey, this is kind of pushing the envelope. And if it pushes any further, there's going to be some more harsh feedback from the court. So in and of itself, the potential, a judge making an announcement of the potential remedies that may be imposed in the future, I don't think that's a reason justifying relief. Now, the concerns related to the counseling for the child and the false evidence presented allegedly by Mr. Curtis, I think those fell on their face. Just a facial review of that. Also, the issues regarding the derogatory comments, the child's name change, the mental health evaluation. I think there's sufficient within the record to support those, and I think it's insufficient showing of any misconduct of Mr. Curtis. And the thing also with the timing, it's important to keep this in mind, is that memories fade, and at the time motions are brought and decisions are made, that's generally the best time to address them. Granted, the rule allows, at least for some portions of CR60, to be brought within a year, but a reasonable period of time, almost a year or so afterwards. I'm not going to make a ruling that it's not within the time frames, but it sure indicates that there was. It suggests that with the filing of the other Mr. Curtis's motions, that this seems a bit same back at you type action. So, and I think it's also important to note, as argued, that there was, at the time, there was no motion for reconsideration. Often motions for reconsiderations are great checks and reminders for judges. Sometimes during a busy docket, a judge may make a decision, and then upon further consideration, like, wow, I really kind of went too far there, or I didn't consider this, or there was insufficient evidence there. And that's why motions for reconsiderations are a great tool. It's helpful to the court. There was none of that was not filed here. There was not a motion to, overturn or revisit or supplement the record or anything of that nature. So I think that's very important to recognize also. So as far as the CR60 motion, it was well pled, but I just think it's insufficient on its face, and so I'm going to deny the CR60 motion. for relief. As far as the motion for attorney fees, I'm going to award $1,000 of attorney fees. I think that the timing of it, the lack of prompt action at the time, kind of when the sting is most painful, so to speak, that suggests that this motion was brought in bad faith. So I'm awarding $1,000, and that'll need to be paid within 60 days. We'll next move to the motion for contempt brought by Mr. Curtis.
And excuse me. Thank you, Judge. Again, everything kind of dovetails directly to this contempt order. And as you've heard me say, it's pretty clear. Just to put this and include it in the record, that order was entered on July 23rd of 2024. States the mother shall submit to a mental health evaluation with parental risk component. Father shall be provided input on that evaluation. The evaluation shall be conducted by a professional with, at minimum, master's level of education. The results of that evaluation shall be forwarded to each party's legal counsel. Mother is responsible for payment of the mental health evaluation and costs associated therewith. So again, that was discussed, that was clear. It was reduced to writing now, by my count, about 15 months ago. I think it's important, and again, to recognize what got us to this position. This case has been going for an extended period of time. That was recognized by the court at the contempt motion 2 summers ago. Mom, and Your Honor heard this, I want to say 2 years ago. You had made rulings on this, and this was the case where mom had made requests that, well, she wanted to know not just what the child was eating at dad's house, but the amount of calories that were being consumed, literally taking pictures off the back of boxes, what brand of macaroni and cheese, those types of things. Your Honor had said something along the lines of, that is concerning because it shows somebody who has major control issues. My hope was, and again, this was, I believe, 2 attorneys ago for Ms. Wynn. My hope is that the parties could take that springboard, use the information and try to learn to co-parent effectively, that things would get better. Unfortunately, since that ruling, mom has only dug in more. Things have gotten worse. This is the same case. And again, if you read the motion that led to the contempt 2 springs ago, this decision-making was violated. Mom would make kind of these appointments for the kid. Dad would be left in the dark, treated essentially as a second-class parent, which he's not. Court found contempt. Mom would remove the child for various reasons. Again, we provided the records of that. That's one of the contempt findings. The derogatory comments, and I think, again, this is in direct correlation to the court's order that Your Honor made some time ago, about what kind of emotional impact mom is putting on this child. This child loves both his mom and dad. He has a right to love both his mom and dad. That is a healthy, good thing. Unfortunately, mom, and again through the conduct, is making it clear to this child, whether she's directly telling him, which we believe she is, or implying it. She arms him with a Leatherman and a pocket knife and says, here, your dad's essentially dangerous. Take this with you to your dad's house. If anything happens, use it. Kid then takes it to school. My client had no idea about this stuff. Takes it to school, gets in trouble at school because he's got a knife at school. Mom, again, the same capacity, encourages child, well, we're going to change your last name. We're going to remove Curtis, or we're going to minimize Curtis, and we're going to put Quinn in there. If you look at the information, again, that's been provided last summer, as well as most recently, which is part of the motion to modify, you'll see that she keeps putting Wynn. She keeps changing this child's name. She keeps encouraging that. The court recognized, again, that that's damaging. Whether you're telling your child specifically, hey, Curtis is bad, we don't want to use that, we need to use Wynn and Wynn only, that's a form of enmeshment. That's a form of alienation. The court has recognized this throughout. I will be interested to see what the GAL, how she comments on that, but these are clear issues that date all the way back to 2020 when Miss Wynn initially started withholding this child under the guise of COVID. Well, he can't come to you because of COVID. Well, you're violent, so I'm not going to send him. I'm not going to respond to you. Just basically stonewalls dad throughout. And again, this has been the arguments that have been made since the onset of this case, recognized by Judge Hahn in the summer of 2024, which led to, and I'll use Ms. Green's term, pretty severe sanctions, because this is very extreme and severe conduct and behaviors that mom continues to put in this child's head. Fast forward. If we look at the ruling of the court, and again, Judge Hahn had, and it's contained in the record, these actions are all highly inappropriate. The mother shows significant control issues, which are likely impacting the child to a negative degree. She goes on to state that jail time, again, as referenced by Ms. Green, would be considered in the future if the same conduct persisted. And again, I would agree with Ms. Green. It was a pretty severe remedy, because this is severe conduct that we don't typically see. I've never seen in 20 years where one parent says, hey, here's a knife, take this to your mom's house or your dad's house because somebody over there is dangerous, when literally none of that is in the record. That's a court's decision, and the court would obviously never tell a parent, hey, give an underage child a weapon to use against the other parent. But that's something she's unilaterally deciding to do, and the court recognized that. And of course, they're going to say, if you keep doing that stuff, there's going to be jail time imposed. If you look at it, and again, and we look at Lady Justice as blind. If we look at somebody, and we had a dad who said, hey, take this to your mom's house because she or a boyfriend or new husband or somebody is dangerous, that would be problematic. It's the same type of problematic when we have a mom with control issues as recognized by various judicial officers to say, here, take this to your dad's house, use it against him if you start to feel uncomfortable. That's an issue. So if we look at this, and Judge Hahn had indicated, we had requested at some time or commentary on that, counsel, from what I recollect, objected to that at the time of the hearing in 2024. Well, it wasn't formally pled. This was so significant that the bench at the time, from again what I recollect, decided, you know what, a mental health evaluation for her with parental risk component is appropriate given the circumstances, because this is outside the box of what we typically see and the conduct is significant. So we have that, and it's a very clear order. These things, I understand, take a couple of months usually. Typically, though, when an order is presented, it's entered. Again, as counsel, you tell your client you've got to comply with a court order, whether you agree with it or not. You need to do this. What we have right now is absolute stonewalling. You saw that my office gave time to get this done. This order was entered in July. We started reaching out, I believe, via phone calls after the first of the year. We start reducing those to writing in March. If you look at the history of that, and again, I think it's detailed in my client's declaration, but we started with the communications, and I don't want to misidentify what these are. We provided you the emails on March 21st. We reach out. March 27th, another email goes out. March 31st, another email goes out. On April 29th, now after a month of me getting, and my legal assistant getting absolutely no response. And again, it's clear. We gave you the communications. It's friendly, it's direct, it's to the point. To Ms. Green, her legal assistant at one point responds and says, I'll check on that, or I'll talk to the client and get right back to you. We don't hear a word. I start taking the initiative and the reins on that, reaching out directly to Ms. Green. I don't hear a word. Finally, after more than a month, about a month and a half, on April 29th, I reach out to the GAL, Ms. Corey. I say, Ms. Corey, have you heard anything on this? This needs to get going. This is information we absolutely have to have given the circumstances. And prior to setting a trial date, Ms. Corey gives her response on the same day. And again, that's important to recognize. I haven't heard anything from Ms. Green. My client hasn't heard anything from her client. My client hasn't heard anything from potential providers in almost a month and a half that we've been persistently asking. On May 6th, we send another communication. I don't hear anything. So that is intentional stonewalling. We don't have, again, as Your Honor attributed, we don't have any kinds of motions pending. We don't have anything. We are literally waiting for the first domino to fall, which is the mental health evaluation with parental risk component, which then will lead to the second domino, which is new input from the GAO, which then will lead to the third domino, which is we can finally schedule a trial, we can get this matter heard, and we can get some much needed conclusion for this young man and two families. And we don't have any of that. If I would have gotten any kind of response, if I would have gotten, hey, she's working on it, or hey, do you have any suggestions for providers, which they suggest it was our duty to do that. And certainly that's would be unique or unheard of, basically. We don't get anything. We're just ignored. And again, it's easy to miss an email here and there. You can't miss 1, 2, 3, 4, 5 different communications, which doesn't even consist of the phone messages. So you've got at least 5 written communications before you of us asking for this information, and we don't get so much as a word back, which then eventually prompts the motion to modify and the motion for contempt. This is clear. This is intentional. This is by design, and this is right in line with the court's concerns back in July of 2024. Your Honor, this is right in line with your concerns back upon, the opening round of temporary orders, where you said there's some control issues going on here and this is concerning. They've gotten worse. So here we are. I think this is clearly a willful, intentional violation. And the part that really concerns me is the explanation and the response we get from mom. She insinuates, well, it's Miss Rosen's fault, because I called Miss Rosen. Again, she didn't call her till the spring after we started sending these messages. And she said on her voicemail that she'd get back to me within a day, and she didn't. So it's Miss Rosen's fault. She then says, well, it's Kaiser's fault. I reached out to Kaiser. Look at the timing of this. On March 27th, which is a day I sent a communication. I believe that one was directly from me to Miss Green asking, hey, what's the update on this? About a week after my assistant initially reached out to the law office. She says, provides information from Kaiser on March 27th that says, yeah, we'll essentially get back to you. She details for you all these communications she had with her attorney, which I don't think you can consider, and I really don't think they're relevant whatsoever. But no explanation for why nobody responded to my direct inquiries, or likely the inquiries directly from Ms. Corey as the GAL investigating this case. We then have, she goes, well, Mr. Zandy didn't, or Mr. Curtis didn't reach out and tell us available providers. This is somebody with extreme control issues. Do we think for 1 second that if I made a suggestion to Miss Green or her client, or my client did the same thing, that they would follow that? Absolutely not. And again, that's just more, it's just more smoke. That the fact that she cannot take accountability for one thing is concerning. I had to read through, and again, I'll get to my objections over their pleadings here momentarily. I had to look through everything multiple times to make sure, especially her response to the contempt, to make sure I was grasping what she was trying to say. The fact that somebody takes absolutely zero ownership and zero accountability after what the findings of this court by multiple judicial officers has already been absolutely floors me, and it concerns me moving forward that she's never going to get into the position of being the co-parent, making decisions that are in the well-being of this child, realizing that this child is 50% her and 50% dad and deserves a relationship with both. And she basically, by her conduct, says, well, I don't want to do it, so I'm not going to do it. And she doesn't come out and say that in any of her responses. By my count, there was 4 or 5. She doesn't come out and say that, but she implies it throughout. The fact that we are now 15 or 16 months after the order was issued, and she's still arguing the fact that she shouldn't have to do it. Well, I'm on furlough. Well, that furlough is brand new as of the past month. She wasn't on furlough for the prior 14 months before that. She made no qualms about that prior to that. She has money. She's well employed. She works at the Social Security Division, but it's excuse after excuse. It's somebody else's fault constantly. She can't take accountability for it, and that's concerning. This is clearly contempt. This is one where she has no design to follow the court's order. This is one where she continues to do the same behaviors and actions, which again are to a detriment to this child. And as the court said prior, these actions are all highly inappropriate. The mother shows significant control issues, which are likely impacting the child. And here we are again with more egregious violations. I'm not sure this one tops arming your child with a knife and a Leatherman tool to take to dad's house to in case you need to stab him, but it's pretty close. This is in direct spit in the face of the court by saying, I know you've ordered it, but I'm just not going to do it. And it's everybody else's fault but mine. That's a problem. So we are asking that you find contempt on that. It is certainly willful. It is certainly intentional. And she doesn't even say she's willing to comply. I doubt she actually does. And that will lead into my comments on the modifying the parenting plan. But we are asking for the finding of contempt, also asking for $2,500 in fees, asking for a civil penalty of $500 because, again, this is very egregious. And we keep coming back on these types of issues. And we've essentially wasted a year because she just refuses to comply, knowing that we need that information desperately before we can finalize this case.
Thank you, Mr. Zandy. Ms. Green?
So first I have to address the misrepresentations. Mr. Zandy continues to reiterate this issue about a knife and saying my client armed the child with a knife to take to father's house. There was a CPS investigation. The child identified that Aoife's fearful father did not identify that mother gave him a knife. The school did not identify that mother gave him a knife or encouraged him to take the knife to father's house. The child took the knife to school because he felt unsafe. That was what he stated. So these continued supposition that my client armed the child to take a knife to his father's house is not accurate, is not what's in the record, is complete misrepresentation and just speculation from Mr. Zandy's side.
This is a finding of the court under paragraph 4 of the contempt order that says she provided the child with self-defense devices, knife and Leatherman, so he can use them for, quote, protection from the father. This is not a misrepresentation. That's a big word, and that needs to be nipped right in the bud because it's not. That's a court finding, Ms. Green. You signed the order.
So regarding my client's position on that, as I addressed, my client denies that she gave the child a knife and directly states that the child picked up, it was his granduncle's knife that he took with him to school because he felt unsafe. My client did not direct him or did not encourage him in any way. So I need to address that directly. Specifically regarding the evaluation, not specifically pled, it was not in the motion for contempt. It was not requested in the motion for contempt that the evaluation be completed. It was argued at the hearing that my client's actions are so egregious that, and in Mr. Curtis's declaration that my client's actions are so egregious that it required a mental health evaluation. So again, we dispute that the court made a sua sponte order for this mental health evaluation. It wasn't specifically pled in the motion. It was argued at the hearing and in Mr. Curtis's declaration suddenly that this was necessary, and it was ordered by the court in the contempt. Since we're pursuing that contempt, the last thing I want to state that Mr. Zandy said that he didn't believe there was any communication to him asking for providers. It was provided to him. It's in our declaration, and supplied as Exhibit 2. We provided actually the whole communication that on September 6th, Mr. Zandy responded to our email. Our email specifically stated at the end, which is marked, "Finally, my client is seeking out a qualified professional for the mental health assessment, but please advise if you are aware of anyone in particular the court would refer that qualifies, as I am not familiar with the local professionals in Cowlitz County and would likely refer her to Clark County professional if another option is not provided that meets the court's requirements for the mental health assessment." I specifically reached out to Mr. Zandy in September 6th after the contempt finding to ask for guidance because I was not aware of a provider in that county that provided that assistance. My client had the same issue trying to find a provider. In fact, in her declaration, she provides all the communications and actions taken since the contempt hearing to try to find a provider. The list is pretty clear that there is ongoing attempts to try to get this assessment done. She contacted me. I contacted Mr. Zandy. There was no response from Mr. Zandy regarding that. Instead, he is responding to the issues with the child being taken out of counseling, but no response to that specific request about providing a provider. I had provided my client, Miss Rosen, who was the only professional I knew in the area that provided some kind of evaluation, not aware of what she provided. Again, my client provided an update where she contacted her mental health provider, she contacted Miss Rosen in September 16th, 2024. So this is just 2 months after the request was made. So there was no response from Ms. Rosen a year ago at this point. She contacted subsequently 2 days later Kaiser for a referral from her doctor. She contacted my office and advised that there was no response from Dr. Feng or Dr. Rosen. At this point, I don't have any information to provide to Mr. Zandy because we don't have a provider. I'm still waiting for Mr. Zandy to provide some referrals as I requested. No response from him. My client provided a treatment summary from her doctor that provides her mental health evaluation to the jail in October because there's been requests for some information. My client provides what she has available to her at that point. Again, my client follows up for a request with Kaiser back in March. She completes another request for a mental health evaluation with the Dr. Shaw. From March through July, she checks the KP portal for mental health assessments for appointments to be scheduled. In July, she contacts another Kaiser member asking for a mental health assessment to be scheduled. She gets referred to a therapist who finally tells her only at that point that Kaiser is not going to complete these assessments.
I'm just going to object to any hearsay, Judge, because this argument is full of hearsay.
Objections noted.
And the documentation of all this communication is in the record and provided as declarations or as exhibits. I apologize. Showing the amount of compliance she has attempted to get a mental health provider at this point. So at this point, my client has not been able to provide. Then subsequently, after the motion, she follows up with Ms. Rosen and still has not been provided any reply. Saying that she was expecting a reply within the same day is her note that Ms. Rosen's statements and emails say that she will respond within 24 hours. That did not occur. She did not expect a response within 24 hours. In fact, she contacted Ms. Rosen on July 17th. This is a year later. She submitted an online appointment request on July 14th. She contacted and left a voicemail again on July 31st. And again, no response, left another voicemail August 12th and August 25th. At this point, until the arguments today, we were not aware that Ms. Rosen may not qualify for this mental health evaluation. So the concern is my client has no direction or insight on who to contact. We've asked Mr. Zandy. My client has gone to her providers. My client has gone to other providers I suggested. And at this point, we don't have anyone that can complete this mental health evaluation. So saying my client is non-compliant and not willing to comply is completely false. She has made all these attempts and requests to follow up and do this evaluation, has had no insight from Kaiser as a referral, has no insight from Ms. Rosen to respond to scheduling if she's even qualified, has no response from Mr. Zandy asking for qualified providers. I don't know what else my client can attempt to do to complete this evaluation without the court appointing somebody at this point to complete the evaluation because she can't find one provider. And now at this point, based on her financial circumstances, we do have issues with her actually complying until there is funding available for her to do so. She cannot afford this. She's already addressed in her pleadings. She's taken out loans on her home to pay for this litigation because of her concerns for the safety of this child. Not a control issue. She is concerned about the safety of this child. We'll go on to it in the motion for temporary orders, but there's been severe neglect and issues with father's care that need to be addressed. And so if the court wants to proceed again with this evaluation being done, she needs some guidance and assistance. She can't afford it. And at this point, she's going to have no providers available to our knowledge that are able to do this.
Thank you, Ms. Green. All right, so the motion is for contempt. But on July 24th, probably 23rd of 2024, the court directly ordered Ms. Wynn to obtain a mental health evaluation with a parental risk assessment. GIL would then have opportunity to provide collateral input as well as Mr. Curtis. Dr. Calver submitted a document in July of 25, and he specifically says this does not serve as a for purposes of a mental health evaluation, but it's just a summary of how the treatment's been going. So obviously, and there's no representation that that was represented to be a mental health evaluation. Ms. Wynn in her response indicated, quote, "I have not obtained the mental health assessment." So the argument from Ms. Wynn is that she contacted two individuals, Ms. Rosen and Kaiser, or two organizations. There's no showing that she opened up the yellow pages, if that's such a thing anymore. No indication that she did a Google search and said, please provide mental health providers within a 50-mile radius, 75-mile radius. There's no indication that she asked the state of Washington or looked at the state of Washington licensed professionals in a particular radius. There's no indication that she called any other mental health professionals asking for guidance. By my calculations, roughly 15 months, you consider there's 20 working days, probably a little less due to holidays. That's roughly 300 opportunities, 300 days, specific and separate days in which a person, if their desire is to comply with a court order, they'll find a way. And I'm a bit troubled with the idea that if just the comment of, well, if the court still wants to do the mental health evaluation, there's not a big eraser here that's erased that July 23rd, 2024 order. It remains intact. It remains in full force. And to suggest that the court would then change its mind or say, nah, just kidding, is a little bit concerning. So I also think, I wonder, there's collegiality within the bar, and then there's a representation that opposing counsel didn't call me back and give me a recommendation. It's not opposing counsel's job to provide recommendations as to providers. That's squarely upon Ms. Wynn. And if Ms. Wynn wants to employ the services of her attorney to help find that, then that's great. If her attorney isn't in a position to do that, then Ms. Wynn is going to have to. She's the one that's subject to the contempt power of the court, not Ms. Green. So Ms. Wynn is fully on the hook to comply. I think it's also important to recognize that, even though there's argument, I'll just touch this briefly. It doesn't need a lot of airtime, but the mental health evaluation, not necessarily or discreetly pled, and then the court ordering that. And the fact of the matter is that sometimes issues come up in a hearing where the best interest of the child very well may be served by the court taking a specific action. And the court, to my knowledge, is not, its hands are not tied to order sua sponte any services that would best serve the best interest of the child. So the court can require that. And if a party feels aggrieved by that, then they could bring a motion for reconsideration in a timely fashion. So, it's been since July, and there's no real headway at this point. And so, if a contempt order is filed, and then I hear back from Kaiser or in that general time frame, and they say, hey, we can't do that, I'm scrambling. If I'm the one subject to the order, I am scrambling. I am making my best efforts. I'm calling people. I'm writing letters. I'm sending emails. I'm not seeing that. I'm seeing two organizations or individuals that were sought and were through which mental health evaluations potentially could have been given. When that dried up, I am giving my highest priority to finding somebody that can provide the service that the court directly ordered. I'll make a finding of willful and intentional disobedience of the court's order from July 23rd, 2024 by Ms. Wynn. I will impose a $500 civil penalty. I will impose attorney fees of $2,500. Ms. Wynn needs to accomplish and get that mental health evaluation with parental risk assessment, with collateralized input done ASAP. We'll move to the next motion.
And finally, Judge, and I'm going to be quick on this one. I think it all kind of boils down to this, and that's the motion to modify at this point. And again, my client sets forth A lot of the concerns you're already aware of. There's others. Again, the emotional impact on this young man, I guess from my kind of review, the sad part is it doesn't need to be this way. And again, this is a kid. I've said it before. I'll say it again. I've said it in this hearing. I've said it in others. Kids deserve to know both parents, to love both parents, that both parents respect each other, and everybody cooperates to foster the best interest of the child. We simply do not have this, and we have never had this. And not to sound skeptical, I am not sure we ever will have this. And the impact, and again, moving forward on Benjamin, who is a young man coming into his own, is concerning. We have very definitive signs of parental alienation. We have certainly the withholding aspect back in 2020 when my client was very much involved as a parent, and mom just ghosts him essentially, decides that she's not going to respond, doesn't give any time with the child, leading to where we are today. She still has those same thoughts, those same actions, those same parenting behaviors. There's certainly enmeshment going on right now. And my concern for the enmeshment, continues to grow on that. We've got a young man who is looking at kind of what's happening with mom. And again, it goes back to this Leatherman. And certainly, if you're going to throw darts about one attorney or one party misrepresenting or lying, those are words that we can't take lightly, and it's quite offensive. But again, as it pertains to the Leatherman and the knife, it's the court's made those findings. That's not coming from me or my client. It's coming from the court. And you've got a parent who's providing this. Child takes it. Child goes with it. Child gets in trouble with it at school. Again, whether that was designed to be a dad or just to defend himself at school, it's inappropriate. That's very concerning. And we've got, again, somebody who's basically teaching this kid, mom is good, comply with what mom wants, conform with what mom wants, and all will be good. And even if that's at the extent of alienating dad, that's just the way it's going to be. I'm always interested in this, and I think we can look even further on this. And I'd be interested to get Ms. Corey's input on this or another professional. You can kind of see that. If you look through the pleadings, my client has stated from day one that this is right. Page 1 out of her playbook, she did the exact same thing with her first, I don't know if it was a boyfriend or a husband when it came to parenting, alienated that individual. And you've got now her adult daughter who every single case, and the adult daughter has no input on what the contempt is. The adult daughter should have no idea what child support issues are, is drafting declarations on her mother's behalf. Interestingly enough, Miss Green, again, asked, and this is multiple times, and most recently as of a couple days ago, sends a request to appear via Zoom and puts this same witness, Miss Wynn's newly adult daughter, on the list so that she can appear on the Zoom calendar. Court denied that a couple of months ago. Now, since this is all Zoom, fine. I didn't raise an issue with that. But that shows enmeshment, and that shows a pattern. We do not want, my client will not do it. My client wants to be a parent. He's a good parent. He wants to be a part of this young man's life. He should be a part of this young man's life. He is a good father who loves his child. There's nothing outside of argument and, well, there was this or there was that, or he's neglecting the child. The only person who thinks he's neglecting the child is Miss Wynn. And again, the same person who is arguing to this court that he should be the parent who counts calories and sends it back to her and takes pictures of the back of boxes to show the caloric intake, the sugars involved, all of that different stuff, because she wants to know and have her fingers on everything. My client's detailed for the court in one of his prior declarations. The same parent who conveniently ends up at the same park that him and Benjamin are at. The same parent who, again, goes to providers. And I think it's interesting if you look at this. If you look at some of the information that she reports in her declaration, she says, well, Jad is incapable of caring for Benjamin's dietary needs, and meal times are bad, and he puts him to bed too late. That's all hearsay from the child, but regardless. She then goes and reports the same things to the doctors. I think it's important if you look, and I don't know how close we were able to do that, but if you look at the information that my client provided you in the email from Dr. Manlapaz. I hope I'm pronouncing that right. She seems utterly and thoroughly annoyed in her response to Miss Wynn. Miss Wynn's complaining about, well, Benjamin comes home from dad's and he doesn't smell good. Well, Benjamin's not allowed to use the phone as I want him to at dad's house. Well, Benjamin was up too late when he was at dad's house. If you look at the response from Dr. Leah, she's basically saying, well, figure it out. Your parents co-parent through that. This is not a medical issue. This is a parenting issue. But what's mom do? She goes to providers. It's the same reason that she went to handpick the counselor for Benjamin. So she can fill that person's with information, knowing that it's going to eventually come to court. And this is about as poorly done and transparent as I've ever seen. And as all it takes is my client to reach out to the doctor and say, hey, is this true? Can I get information on that? And here we have the email from the doctor that says, well, the cell phone, figure it out with his dad. Maybe this is something that you and Jad need to get together with. Maybe you guys can mediate it. She says again, at Benji's age, the responsibility should be on him to take a shower and to clean himself. So we've got mom who continues to try to pull in other people by giving them very specific information that works, that she wants you to know about. And then for those professionals to glom onto that. Same thing with the CPS investigation. She tells her counselor something about what's happening. As a man, knowing he's a mandatory reporter, he has to call it in. CPS says, yeah, there's nothing here. It's the same thing we have from the school. She says, well, I'm not encouraging the child to change his name. Look at the information we gave you. That's exactly what she's doing. Either Benjamin or her is handwriting in a different name on the documents that come back. That is sad. And it hasn't gotten any better. It's the same type of behavior that she's engaged in from day one. And the more she's told not to do it, the more she does. And again, I think the court's findings from July of 2024 about these behaviors are not good for the child and affecting his emotions negatively, again, I think should be certainly considered today. I think we could go back in time several years when Your Honor was on the docket. Again, your findings of that day, we didn't know it was going to be this bad. I think we were all hopeful that it would be better. It hasn't. If you look at the laxative information, again, she sends my client a very direct email telling him, this is what you're going to do with the laxatives. You're essentially going to force our child to take this amount of medication. You are going to force our child to sit at least for 5 minutes in the bathroom to do his business, 5 minutes after breakfast, 5 minutes after dinner to train his bowels. And you're going to give him this amount of Miralax. And you're going to look to make sure that his stool is like a mashed potato. She's telling him what to do. That my client, to his credit, says, okay, can I get something from the doctor that actually confirms that? That's right in line with, you're going to count the calories and report back to me. She treats him as a second class, not even a second class. She treats him as some kind of an object that's just an annoyance to her. If we look at the other communications, and again, this is why she doesn't want to take the mental health evaluation with the parental risk assessment. She's careful what she gives you. She gives you information from her provider. It's been her provider for some time, saying she has various ailments. She has the PTSD. She has the major depressive issues. She has anxiety. She has all these different things. What does my client tell you? Well, that's self-reported, and we can all agree on that. And it also doesn't detail some of the other peculiarities that mom has engaged in for some time now. One of which, in what she's asking my client for his father's death certificate, because it's an issue related to Benjamin's health. She doesn't say why or how. She's just saying, hey, you give me your dad's death certificate because I essentially want it, but I'm not going to tell you why. I'm just going to give you a vague, generic, because it affects Benjamin's health. That's unusual, and that's concerning. The same person who tells my client in the past, hey, listen, I'm a federal worker, therefore I'm not going to open my mail because there's going to be anthrax in it because everybody's trying to poison us federal workers. Again, that's not somebody who is emotionally sound. What's the impact on the child? We don't know. But what we do know is an impact on the child is somebody who is stating to this kid, withholding him from another parent, stating to this kid or implying to this kid, hey, your dad is somehow dangerous. Here, arm yourself and take a knife or a Leatherman. Somebody who is encouraging the child to change his last name. Somebody who has a history of this, and she certainly does. This is the type of stuff that this is at risk right now for Benjamin. He's on the verge of the teenage years. He's on the verge of the middle school years, which can be awkward, I think, for under the best circumstances. He needs some stability. He needs some consistency. He needs somebody who's not going to corrupt his mind by saying the other parent is bad. To my client's credit, and again, we don't typically see this, he has never done that. He has always tried to comply. We gave you text messages, and this is where you can see some of the enmeshment with the older child. Older child says, oh, I saw Jad do this or that, and he did X, Y, and Z, and he withheld Benjamin, and I would offer he would never give anything back. That's not what the text communications show. My client gave you text communications that he had with Jade, again, the adult child, talking about Halloween, talking about making cookies, talking about spending time with Benjamin, making time so that Benjamin can see his older half sibling. That's not somebody who's withholding. That's not somebody who's doing the very things that this Jade person puts in her declaration, which we can only surmise is directly from mom, because it echoes exactly what mom wants you to know. Same thing with the other lay witness declaration. Mom provides one, I believe it was from a current boyfriend or a former boyfriend. Sounds just like mom. We can't give those any reliability. We can't assume that, well, mom made this allegation up, therefore it's true. That's what the GAL is charged with. And I haven't seen any of those findings from Ms. Corey. Again, when the court confers with her today, I'm certainly happy to correct my statements if necessary, but I don't think I will. None of these are findings. They're just throw as much at the wall and see what sticks and hope it sticks and go from there. And this child doesn't need this. This is extreme actions. Benjamin deserves both parents. He deserves two healthy parents. And right now, we don't know if mom's healthy because she refuses to take a mental health evaluation, but we can assume she's not based on the actions that she continues to engage in. And that's detrimental to this child. We do not want him to be alienated from anybody. We do not want him to be enmeshed with one party, where one party is basically making this child lose his or her identity or self of expression because they feel so obligated to that parent. I think we can see the evidence of that. We shouldn't have kids withheld from the other parent, absent very good reason. Mom's done all of those things. And of course, there's a psychological impact as a result of that. We've got mom who will not stop until my client is completely out of the picture, just like she did with the older kid's father years ago. And my client tells you, I'm not going to do that. I love my kid too much. I'm not going to walk away. I'm not in a position to do that. What we are proposing is that my client have primary custody. I think it's long since time for that to happen. And we're asking that basically the court go back to what we had submitted back in August of 2024. We had proposed a parenting plan, and that was due largely in part so the GAL had something new and fresh to work off, given the contempt findings and the issues that had permeated in this case over the past 12 months or so at that time. We're asking you to adopt that. We're not limiting mom's contact with the child. I think that would be detrimental to Benjamin. But more detrimental to that would be continuing in the same system of having to appease mom and having to listen to whatever he's listening to. And I unfortunately think we're just at the tip of the iceberg as to what's going on there and what this kid is subjected to. Have him be with dad. Dad lives in a home by himself. It's comfortable. Benjamin has his own space, his own room, the same work schedule. We're in a good spot there. Mom gets the visitations according to what we had proposed in 24. And we've got to get, again, this mental health evaluation. Given that, I think mom partly knows, and this certainly can be, I think, reasonably argued. Mom knows of the issues right now. And her way of she's got custody, so she's thinking, well, great, I've got custody. Why would I ever submit to a mental health evaluation? Why would I ever give JAD and the GAL input to that? Why do I want any of that to come out? Because I've got custody now, which I think is probably warrants the delay tactics that have been imposed over the past 15 months. This child, we're at a fork in the road. This child needs some resolution. This child needs to be healthy. Not just physically, but emotionally. He needs to be able to act like a 10-year-old, 11-year-old, 12-year-old, 13-year-old boy in time, regularly and normally. And I think our proposal certainly accommodates that. I think it's certainly in his best interest, and I certainly think the time is now to make that change.
Thank you, Mr. Zandy. Ms. Green?
Yes, Your Honor. I just want to be cognizant. This is scheduled till 10 o'clock. I just want to make sure how much time I have.
Much time as you need.
Okay, thank you. So, my client obviously has been taking care of the child throughout his life. My client has provided information, medical records for the child, substantiating the issues with father's care of child. Specifically, the child had a bowel cleanout because he was not um, able to have bowel movements and was suffered through 3 days of a bowel cleanout because of the impact of the dietary issues going on. My client is consistently in contact with the doctor, providing the dietitian's recommended diet and schedule, and this still caused an issue with the child. And it hasn't been through any actions of her own, but what's going on with the time with father. This has
I'm
only
going to object to
happened.
that. There's nothing in the record that says it's due to what dad is feeding or not feeding the child. Again, this is just based on Miss Wynn's, what she believes is happening. There's no evidence of that.
Objection noted.
So I would say that this issue has only occurred since father has had substantially more time than in the past. So to correlate that, this issue has only occurred as a result of father's expanded time. Following that bowel cleaning, my client advised Mr. Curtis that the child needed or was recommended to have Miralax on a regular basis to make sure he stays clean and clear and has regular bowel movements. That request was not followed. Basically, father has told mother, I don't have to follow these instructions. Stop sending me this information. And did contact the doctor. The doctor's communication is in the record stating that either a healthy diet or the Miralax can be provided. At this point, my client's consistently providing the Miralax, but it's an inconsistent care for the child because father won't provide the same care while the child's with him. Additionally, Mr. Vandy speaks about hearsay of the child saying he's up all night. We actually have declarations from several family members, my client's current partner and the child's sister, that they had regular activities scheduled during the summer after father's time. The child comes back extremely tired and hungry. This isn't hearsay from the child. We have pictures of the child passing out in the middle of the day, my client having to miss work because the child is not up for 12 hours after returning from father's home. This is not a normal child that's being taken care of adequately in father's care. This is a child who's exhausted and hungry, returning from father's care and needing additional assistance from my client, where she's missed work multiple occasions because the child basically has fallen asleep and is not like able to be woken up for more than 12 hours after these visits with father. This is not adequate care by father that he should be a primary care provider for the child. He's not been involved in any of the child's medical decisions or care. He only contacts them when my client provides information that there are concerns or issues, and only to counteract what my client's asking for as far as treatment for the child. She's asked for a clean diet so that he can have bowel movements because it has been an issue. Client had a bowel issue, and so she's asking for his compliance. His compliance, there's none. He won't either respond to her messages or he contradicts it and says that I don't have to. The doctor says that's not necessary. My client provides information about the child's sleep schedule and says, child's coming back to me and he's exhausted. Is he getting adequate sleep? Father just completely ignores her, says, not, I don't have to answer your questions about the sleep schedule. My client identifies that she's missing work because of it. Still, no response from father. This isn't a parent who's not co-parenting. This is a father who wants to do what he wants during his time, no matter how it affects the child or my client. This is not a parent who is adequately prepared to take care of a child. In fact, the record shows that there are issues like a lack of communication with the providers unless it's necessary. The child was removed from counseling services because father refuses to comply with signing an agreement, which is in the record, with the declaration that I provided in exhibits in communication with Mr. Zandy previously, asking why the child was removed from counseling. This isn't a parent who's willing to co-parent. He's only willing to be obstructive and doing what he wants during his time, no matter how it affects the child. The continued the continued derogatory talking of my client isn't what is going on in this situation. This child has been taken care of by my client primarily because she is an attentive and caring parent. She has an extensive family that the child is involved in. She has taken care of his daily needs in school. She's taken care of his daily needs and medical needs. Father has not been involved in any of these situations unless it's absolutely necessary. In fact, we have declarations where his prior child reached out to have a relationship with his half brother that has no relationship with his father whatsoever. There isn't
I
a.
don't recall seeing that. I don't know who these people are. I would object to anything that's not in the record or again, not provided any kind of a foundation or basis for.
There is a declaration of Cole Black that was filed that
Yeah.
is the child's son.
Yeah, I've read Cole's. I read his declaration.
And so basically at this point, removing the child from mother's care would be, again, extreme, would be harmful, would be damaging to this child. We have issues with medical care. We have issues with adequate sleep and getting to school or adequate sleep, and my client basically being left to miss work because of it. And additionally, we provided records that father isn't even compliant with his child support obligations. So we're asking to remove a child where father has a $500 some odd monthly payment over child support, and he's been in arrears for a year, more than a year. This is not a father who is adequately taking care of his child, adequately supplying required care, and able to take care of this child on a day-to-day basis. In fact, it would be counterproductive and harmful to the child to remove the child from mother's home and to father's home, given all this information and lack of care and concern by father of these issues that father just will not address or even discuss with my client. So at this point, I don't think it's appropriate to remove the child or change the parenting plan unless it's to limit father's time, because that is where the issues have occurred, is the issues regarding diet, the issues regarding the child getting adequate sleep. That's what's been happening with father's care. As far as we are aware, that's what's been documented by my client. So father has no declaration supporting that he's an adequate or caring parent. My client has substantial declarations from family and friends that she has been a primary care provider, has provided adequate care, has taken out of time from her work, has taken out time from her day-to-day life to have to take care of this child, in addition to the regular amount of time because of father's neglect and refusal to comply with the recommendations from the doctors. So that's all, Your Honor.
Thank you, Ms. Green. I'm just curious if it would be appropriate just to hear from Ms. Corey if she has any input, and then both parties could take into account her input and then provide additional information. Ms. Corey, I'm not sure if you were prepared to do this or if I'm putting you on the spot, but do you have any input at this point regarding the child's best interest?
You know, it's been a while since I had my hands on this case because of all the delays. I have no objections at this point to Mr. Curtis's request.
Okay. Thank you, Ms. Corey. All right, we'll hear from Mr. Zandi and then we'll give Ms. Green an additional opportunity.
So a couple things stood out to me. So we're talking about, or we heard an entire argument related to what my client is not doing right. And Ms. Green at the end of that said, as documented by my client. So we're talking about lack of sleep. Where are we going to see lack of sleep? We're going to see that at school. Is Benjamin struggling at school? Do we have any information that shows that he's struggling after days he's with his dad? Do we see anything from teachers through the app that everyone has that says, hey, you know, on these days, Benjamin is really struggling. He's falling asleep in class. We don't have any of that. That would be a pretty reliable source from a neutral party that we could consider and take, hold some kind of water in. Medical information. Do we have anything from medical providers that says, you know what, from independent review of this, we have seen that Benjamin is struggling at his dad's house. He's not getting the caloric intake he needs. He's suffering as a result, and he's quote unquote neglected, as Miss Green and Miss Wynn would present to you. We don't have any of that. as much and as often as she takes this child to the medical providers, and again, we can go back to the doctor's responsive email to her that basically says, if I'm reading between the lines, stop annoying me. If we can look at that, we don't have anything from the provider saying, hey, this child is struggling at dad's house. Do we have anything from the GAO? Again, if these problems are this bad, and Miss Quarry, I believe her words were, she's been pretty quiet on her end. She hasn't heard anything in 15 months. Don't we think that if these issues were persisting or actually occurring, that mom, given her control issues, would reach out and say, hey, I asked you to look into this. It came across. Here's kind of one of the concerns I have. We don't have any of that. All we have is mom, her daughter, and who may be a past boyfriend or current boyfriend, give you declarations that we can certainly assume come directly from mom saying, oh yeah, Benjamin's tired when he gets back. Therefore, we believe he doesn't go to bed until 4 a.m. My client, no, that's not accurate. How would you know what time he goes to bed unless it comes from the child, which is hearsay? The same child who's being taught for the past 10 years to be enmeshed with whatever mom wants to hear, mom gets the result. That's problematic, and that's part of the overlying issue of this. You have no reliable information from anybody, and certainly what Miss Wynn gives you is not reliable information outside of, well, I take the child to the doctor, here's his problem, I report back to dad. She doesn't even give dad an opportunity to attend and participate in these things. She largely tells him after the fact, and then my client has to go back, communicate with providers, and try to recreate what actually occurred. That's a problem. You can't have it both ways. You can't say, well, I'm going to keep you excluded, just like she did with counseling, just like she's done with school. But then again, when we get to court, I'm going to say, well, you've never participated, and therefore that's on you. I should maintain primary custody. You can't have it both ways. And again, she can't communicate. She hasn't communicated. She's made no effort to communicate this type of stuff to him. This is not normal. This is not healthy. It's all he asked for. And counsel says that my client made some comment of, no, I'm not going to do it. He's never done that as it pertains to the Miralax, to the medical care, to the suggestions. He's skeptical, as am I. Anything she tells him, I say, you need to follow that up with the doctor and make sure that's legitimate, just given the past. And he does that. He says, okay, can I get something from the doctor, or can I an order from the doctor that specifically states that? That's all he's asking. And he's done it in a very civil, approachable manner. He's not looking at her saying, no, I'm not going to listen to you. I'm going to ignore you the same way you do me, the same way you do to my attorney, the same way you do the GAL in the court. He's not doing that. He's just saying, okay, given the history, I would like something from the doctors. I would like to be part of this process, as opposed to you dictating to me and telling me what I need to do based on your one-sided communications with medical providers. We don't have anything from a counselor that says any of this is going on. What we do have, and again, this is somewhat frustrating. I made this issue before with Judge Hahn. Judge Hahn instituted an order 2 months ago that said no more pleadings being filed on behalf of Ms. Wynn. She filed on July, I believe it was 21st or the 24th, finally a response. We got that CR60 motion around the same time. And then we started getting information on August 26th, 27th, and 28th, trickling in with amended information and supplemental information and the like, which I've got by my count about 168 pages of stuff. Again, not consistent to the local rule. I've looked through it as best as I can. We've got amended declarations. We've got amended declarations of third parties. We've got amended information as it pertains to exhibits, sealed financial information. We continue to get volumes of all of this. We've got over 168 pages of information, not counting the CR60 motion. And none of that says, to the best of my recollection, Jad is failing to do this as a father. Jad is failing to meet the child's need by not doing X, Y, and Z. We don't have any of that from the school, from the counselor, from the medical providers. The only people we get that from is Miss Wynn, her attorney, and her two witnesses, which are, again, Miss Green's terms, family members and friends. How reliable could that possibly be? So without that verification, without anything from any reliable third party, neutral, professional source, it flies in the face of reason. And again, it carries absolutely zero weight. That's concerning. How she would know about a sleep schedule at my client's house, I don't know, because she's probably funneling that to the child and gives him 20 questions as soon as he gets home from dad's house. That's been an issue in the past. It's not healthy. No kid should be subjected to that. I think Ms. Corey's recommendation that she would have no objection to adopting my client's parenting plan, I think that speaks volumes. We are asking you to adopt my client's parenting plan. And the sad result of this, Your Honor, too, and you know the schedule better than anybody, we can't schedule a trial until we have that parental risk assessment. We're looking at an extended period of time before we can get into trial at this point. And that's done by design strategically by Ms. Wynn. She knows the longer she pits this out, the more the status quo is in effect, knowing that trials still on the domestic side get continued for various reasons. That's problematic. Now is the time to do this. We are certainly steadfast in that. We have tried to be patient. We cannot be patient any longer. We've tried to give Ms. Wynn the benefit of the doubt. There, frankly, at this point, is no benefit of the doubt to be given. And her self-serving statements that she continues to make to providers, to this court, to others, show that that's a direct attempt to alienate the child from dad, and that should not be tolerated. It's not in Benjamin's best interest.
Thank you. Ms. Green?
Yes, Your Honor. So my client provided her declaration. Benjamin returned home from his first summer visit with father, July 11, 2025, constipated. So after the first long week with father, it was directly a result that the child ended up returning to her home constipated. So stating that it's not father's fault, it's not father's responsibility. There is something happening in father's house after the first full week he had of summer visitation this year, that affected the child's diet and required him to get needing this medical attention for continuing to have bowel movements. So that is when the records start with the request for Miralax. The records start where the doctor's recommendations are made because he's having difficulty having bowel movements. It's not something that suddenly comes out of nowhere. This is where it starts. Beginning father's week on visits, child's coming back after the week exhausted. There are records showing the child falling asleep in the middle of the day, going to events, going to fun parties, going out to music and events with family, and he just can't even stay awake. That's not hearsay. That's documented. Pictures are provided. This child is exhausted after father's stay. He's coming home constipated. He's coming home having allergy attacks. He's coming home from father's exhausted and unable to even move for 12 hours. This is not hearsay. This is documented from witnesses who have firsthand knowledge of what's going on. State that these are unreliable. I don't know how unreliable a picture is. I don't know how unreliable the communications from the doctors recommending Miralax are. This started during the summer when father had extended visitation with the child, and the child has only suffered more hardships and harm during that time. The concern I have about Ms. Corey having no objections to changing the parenting plan, she also said that she hasn't reviewed any materials for some time in this material, and that was unclear. I'm concerned that she has all this information provided for these motions, hasn't reviewed or considered them at all. My client hasn't communicated because everything is in the record, and I know that the jail has to review everything in the record to make considerations and make her investigation. I don't think she's done any investigation in the last year, and I'm not sure that she's up to speed on everything going on in these records because she wasn't able to make a determination today. I don't think it's in the child's best interest to remove this child from his regular home, his regular family contacts, his regular caregiver. Father has shown that there is no ability for him to provide adequate care based on the child's constipation during the summer he's had the child, lack of allergy treatments where the child's returning with allergy flare-ups, and ongoing tiredness. How are we knowing this child is going to be adequately cared for when father hasn't even had the child during the school week on a regular basis? This is an extreme change in the child's care and would only harm the child. There's no reason to make a major change of this sort when father hasn't shown adequate ability to care for this child on any kind of excessive basis. Even the summertime was a problem. So I'd ask that the court not adopt the parenting plan, have Miss Corey continue her investigation and be up to date on what is going on with this child, with the child's medical needs. And the reason been no counseling records is because child hasn't been in counseling for over a year since contempt was filed, and there was a determination that my client unilaterally made the decision for counseling. Father has refused to sign an agreement for the child to go to counseling. That's why the child's not in counseling. That's why we don't have counseling report.
I'm gonna object to that, Your Honor.
It's
That's
in the record. It's in the it's in the email communication I have with Mr. Zandy specifically addressing this for this matter. So it's in the same email communication that I asked for a provider. So it is documented. It is provided to Mr. Zandy, and that is the reason the child hasn't been able to continue counseling.
If we look at misrepresentation, the email speaks for itself, and you're misrepresenting what that email says. I would encourage you to review that email, Your Honor, if you find it necessary.
So I have nothing further, Your Honor.
It looks like Ms. Corey turned her camera on, so that's usually an indication of desire to speak. Go ahead.
Thank you, Your Honor. I am up to date with all of the pleadings on this case. That's really all I've been able to do since there has been no forward movement in such a very long time. I've prepared for this the last several times that this hearing has been delayed. And yet here we are again eating up my fees with all of this. I am up to date.
All right, thank you. All right, this motion comes before the court for a motion to modify the existing parenting plan, which is a temporary parenting plan, which was entered on March 7th, 2023. It's interesting to note the March 2023 order had a lot of limitations related to alcohol or domestic violence, smoking classes and the like. So it sounds like those issues have been addressed and that they're no longer front and center. So I note that at the beginning. I also note, let me just start off with this. Let me just ask the parties, just curiosity. I can't do any investigation into the case. Miralax, over the counter or prescribed?
Over the counter, but was recommended by the doctor to take on the daily basis because of the constipation issue.
Okay, great, thanks. So let me first start with this. It looks like Ms. Wynn filed, looks like a total of roughly 7 declarations, meaning not necessarily from herself, but from herself and others. Looks like there were six filed. The limit is 4, so it exceeded the local rule. So I'll note that at the outset, that there's non-compliance with the local rule. So the concern here is that the court is focusing on the child, Benjamin, who's 10 years old, I think currently. He may be older, but he's 10 at least at the last time I checked. So this is a young man that has no serious underlying medical conditions. Child doesn't have diabetes, which is a very serious disease. The child doesn't have heart issues, doesn't have neuromuscular issues. This is a child that's relatively healthy. This is a child that has been constipated during the summer. This is a child who's had allergies. This is a child who was pretty darn tired a few times during the summer. This is a child that goes to school regularly. This is a child that there's no indication that the school is saying, hey, this child is needing to go to the restroom 4, 5, 6 times a day, had an accident. This is a child that's falling asleep and missing important educational input. This is a child that's relatively healthy. This certainly the desire to have a well-adjusted, healthy child is every parent's wish. Every parent's wish. Seeking that is a good thing. Demanding it and requiring it and exacting it is another. Blankets can provide great comfort to children. Blankets can provide shelter during a bad storm and can prevent hypothermia. Blankets can also smother. The concern that the court has is that Ms. Wynn, as well-intentioned as she is, I think she's very well-intentioned. I'm concerned that that blanket of security, that blanket of protection, that blanket of warmth is preventing and impacting the child in a negative manner. In that the smothering occurs. Life is not neat and tidy. Life is not exactly as all of us choose it to be. There are always detours. There are always blocks in the road. There is always a hellstorm ahead of us. And notwithstanding our very best laid plans and our very best intentions, the ideal is never achieved. So we have to work with what we have and do the best we can as parents. The issues related to the bowel, are they important? Absolutely, zero question. Is this an issue that's required intensive medical intervention? No. It was a visit to a doctor. The doctor said, try Miralax. This is not an issue of a child who has some autoimmune disease that causes extreme fatigue. Allergies may be tied up with that also. I'm not sure. This is not a child who needs to go often to the doctor for any regular checkups or, for any ongoing treatment for serious underlying medical issues. I think that's really important to understand that this is a pretty healthy kid. I think it's also important to note that these issues obviously are not new. These are longstanding issues that have been kind of brewing and developing over time and taking new forms and growing in different ways. The concern for the last name, I recognize there's two different interpretations and two different explanations to that, and that's an issue. There's an issue about identity. Identity is big in this case. Ms. Wynn is her heritage is from Vietnam. Mr. Curtis, his heritage is, I think, from the U.S. Both those heritages are vitally important to this child. That's who this child is. His heritage comes from both parents, and both parents' heritage is very important. However, trying to force one to have greater preeminence is a concern. The child may particularly like Tet more than Christmas, or may prefer that over Easter. I'm not sure. But that concern about identity and forcing one identity to be stronger, that's an issue that's present. There's concern about diet at the father's home. Many parents don't feed their kids very good food. Many parents in today's world opt for ultra-processed foods. Is that the ideal? No, the ideal is fresh fruits and vegetables daily with an amazingly equal diet that's well balanced. Can that be achieved in every home? Is that the desire of every parent? No, it's not. Is the ideal great? Yeah. Should we seek for it? Yes. Do we ever achieve it? Probably not. And the concern here is that Ms. Wynn is very, very determined to have a healthy, well-adjusted child. And that intention, I think, is too heavy, and it's weighing heavy on the child. And it's putting a lot on a little person to rise up and to live at that level. Is it good to have high expectations for children? Absolutely. Is it good to have a soft landing spot for children when they don't hit those high expectations? Yes. That's what the court comes away from reading the relatively large amount of materials in this case and having heard it before also. And I think also kind of the telltale sign from the medical provider when he's kind of being barraged by information. I think it's a he, it could be a she. When she's being barraged by information, it's like, hey, we need two parents here. You're both free to share information and just kind of take your child and back off. is kind of the sense that you get. And I kind of read through the lines and kind of got the same similar impression that Mr. Zandi advocated. So there's a lot of concerns here. Significant to those concerns are the lack of a mental health assessment and parental risk assessment. There just has not been there. There's been no movement. And there's underlying issues that Dr. His last name starts with a C, Dr. Culver has mentioned that Ms. Wynn is working through. And I really don't have a clear view of how those directly impact the child, other than some of these issues on the fringe that are flaring up and showing concerns for the well-being of the child. So I'm going to grant the motion. I'm going to grant the motion to change to the August 2024 proposed parenting plan with some slight revisions. On paragraph, so let me just go down the path here. So I'm going to include under 3B as in Bravo, emotional and mental health. I'll include that. The withholding, I'm not including that. And currently, the abusive use of conflict, I'm not going to include that, but I will include the emotional and mental health provision. Under paragraph 4, I'll include that, and I'll also include, there needs to be language in this parenting plan that Ms. Wynn absolutely needs to obtain that mental health evaluation and parental risk assessment with collateralized input from Mr. Curtis and Ms. Corey. And it has to have some teeth in it. And I'm not quite sure how big a teeth those need to be, but just suffice it to say, if that's not done in a timely fashion, there could be dramatic changes. As far as decision making, I'm going to grant full and we'll call it, well, it's limited in that it's limited, meaning it's not joint to Mr. Curtis. So he'll have decision-making control for educational and school decisions, healthcare, non-emergent and extracurricular activities. Can mother give input to the doctor? Absolutely. As the doctor said, both parents need to provide input, but the sole decision-making will rest with Mr. Curtis. The primary custodian will be Mr. Curtis. Ms. Wynn will have alternating Fridays, alternating weekends for Friday after school till Monday at school, with the proviso as listed that if there's no school, it'll be 5 p.m. And then she'll have Wednesday after school until 7 p.m. I think that's appropriate. Under the holiday schedule, under paragraph 10, it should include the holidays of Tet and Nyegyo, I think is how it's pronounced. I'll probably mispronounced it, but those two holidays should be included as were in the existing parenting plan of March of 2023. No changes to the transportation arrangements. I think that's identical from the earlier temporary parenting plan. And we'll continue the use of the Our Family Wizard under 14 and all those provisions under 14. And I just want to make sure that I'm not missing anything else. The passport, I'm going to flip all the provisions in the passport. I'm going to give that control to Mr. Curtis. So where Ms. Wynn had control of the passport, basically all those provisions flip, and there Mr. Wynn will have the control of the passport, and then if Ms. Wynn wants to use it, then she needs to follow the provisions that formerly applied to Mr. Curtis. And I'm doing that just because I'm making a fairly significant change here, and the court has concern of potential fleeing. I'm just saying that I don't know if that's a possibility, but I want to hedge against it. And so that passport needs to be delivered to Mr. Curtis by end of business today, or to counsel. That's the court's ruling. Any request for clarification?
Just a presentation date, Judge.
We'll do those on Fridays. So we'll take a look at the calendar. at 8:45. On the 28th is probably a bad day. The 21st,
But I think we're closed on the 28th are we still closed for Black Friday in the clerk's office? I know it's the day after Thanksgiving.
yeah, the clerk indicated, yes, that's closed that day. So the 14th, I don't know if that's a possibility. That may be too quick of a turnaround a week from today. The 21st, I have a Commission on Judicial Conduct meeting starting at 9 o'clock. There's potential we could do it at 8:45 because I'm carrying out that meeting via Zoom. So let's try for that. Let's try for the 21st.
21st.
Actually, Your Honor, I have a conflict. That's my day for surgery. It's been rescheduled, so I won't be able to do the 21st, and I'm supposed to be in recovery for a week after.
Sure.
As soon as I would be available would be December 5th. If we do it next week, I'm in a training in Portland starting at 8 o'clock, so it's a problem.
I'm fine with the 5th, just so long as everybody realizes the plan starts immediately.
Well, when is the transition going to occur, Your Honor? That's going to be the issue.
Could you repeat that again, Ms. Green? I apologize.
When will the transition occur?
Let's see. Currently Benjamin's in school today, I'm assuming, and I'm not sure where we are with the alternating weekends. If this is an alternating weekend that is designated to Mr. Curtis, or if this is Mom's weekend.
We can find that out, but we'll patch that together for the weekend, and then we'll call it effective Monday if the new plan starts.
I think that's fine, Ms. Green. Any concerns if the plan starts on Monday, November 10?
Now let's summarize the case. The judge has weighed in on multiple issues, from the violation of the court's orders to the emotional strain placed on the child. The ruling calls for a change in custody arrangements, with the father gaining primary responsibility. The court also imposed penalties for the mother's willful noncompliance. It's clear the court is taking this case seriously. As for the future of this child, the drama is far from over. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what happens next.
I'm sure my client would ask for later, but obviously the court's made its decision, so I assume that will be ample time for her to make arrangements.
Okay, we'll have it start on Monday, November 10th. I'm also doing just a separate bench order related to the passport being due today, so I'll file that today.
And ma'am, we close at noon today, and I can't stay late. I've got a doctor's appointment myself, so we could get that. That would be great.
I don't know that could be completed in the next hour. Is there a chance that we can extend it to tomorrow? Because I think it'll be easier for her to provide it to counsel rather than bringing it down to me.
Tomorrow's Saturday.
Sorry. I'm not sure what the court wants to do. I don't know that she can get it there in the next hour if she's at work.
She's online now. We could ask her.
Yeah, it needs to be done today. I don't know how she's going to do it, but it needs to be done today. If it can't get to Mr. Zandy's office, then it needs to get to Mr. Curtis.
Okay.
Very well.
So I'll just pen that order, and it'll be due by close of business, which is 5 p.m. So either directly to Mr. Zandy, if it's before noon, if it's afternoon, then it'll need to be given directly to Mr. Curtis.
Very well. Thank you.
All right. We'll see you then, everybody, we said on the 21st at 8:45.
December 5.
Oh, that's right.
Right.
Well, what did we decide? It was the 5th?
December 5th, Your Honor.
Okay. All right.
All right. Very well. Thank you.
Thank you.